Let us see the charge.
My lord, kindly see page number 73.
Yes, Mr. Sanjeev, come on. Take over.
Page number 73, my lord.
I'm panting, Your Lordship, so kindly
You
give a
can
minute.
hold your breath, just point out the relevant, show us the charge.
May kindly come to page 75, Your
Till the
Lordship.
time the court reads the document, you can hold your breath.
Page 75, Your Lordship.
Page 73 is the charge.
Yes, Your Lordship. But relevant in the format that is mentioned at page 75.
Yes.
आरोप अनियमित नियुक्ति. She was directly appointed on regular basis by the inspectors of school Bihar on the recommendation of district inspectors of school Dumka without following the proper procedure for such appointment. No advertisement of the post was made in any local newspaper or agency of employment exchange. No roster clearance was obtained and the reservation rules were also not followed. There are no proceedings of any select committee for selection through interview/test.
Yes.
साक्ष्य सीबीआई से प्राप्त जांच प्रतिवेदन की छाया प्रति.
So, okay, this is the charge.
Yes.
Now, let us see what is the finding of the inquiry officer.
Yes, Your Lordship. May kindly come to Lordship page number 93.
Yes.
संचालन पदाधिकारी का मंतव्य. Lordship, page 93.
Yes.
श्रीमती नीलिमा कुमारी तत्कालिक सहायक शिक्षिका राजकीय कन्या मध्य विद्यालय दुमका संप्रति जिला कार्यक्रम पदाधिकारी भागलपुर के ऊपर आरोप के संदर्भ में विभिन्न तिथियों पर सुनवाई की गई. आरोपित वर्तमान पदाधिकारी द्वारा अपने बचाव में लिखित पक्ष रखा गया. उपास्थान पदाधिकारी ने कोई साक्ष्य अपने अभिभाग की तरफ से कोई उपस्थित नहीं किया. लिखा कि सीबीआई का आरोप पत्र ही साक्ष्य है. श्रीमती नीलिमा कुमारी के द्वारा अपने पक्ष में साक्ष्य रूप में कोई कागजात उपस्थित नहीं किया गया जिससे यह प्रमाणित हो सके कि इनका नियोजन स्थानीय समिति द्वारा अनुशंसित हो. सिर्फ नियोजनालय में निबंधन संख्या 1982 से पंजीकृत है. यद्यपि विद्यालय निरीक्षिका सह उप शिक्षा निदेशिका बिहार पटना को बिहार सेवा संहिता की कंडिका 64(1-3) में नियुक्ति का अधिकार है, परंतु शिक्षिका के नियोजन में कोई विहित प्रक्रिया नहीं अपनाई गई. सीधे तौर पर जिला विद्यालय निरीक्षिका दुमका के अनुशंसा के आधार पर विद्यालय निरीक्षिका द्वारा सीधी नियुक्ति कर दी गई. रोस्टर आरक्षण का पालन नियोक्ता का दायित्व. Before that, the Lordship, may I'll take
Show us the order and then you will.
Yes, Your Lordship. May kindly come to page 101, annexure 12. May I read that, Your Lordship?
Not the entire thing. Read from paragraph 4.
श्रीमती नीलिमा कुमारी से प्राप्त द्वितीय कान परीक्षा के उत्तर के समीक्षोपरांत संतोषजनक नहीं पाए जाने का स्वरूप श्रीमती नीलिमा कुमारी अवकाश शिक्षित पदाधिकारी पूर्णिया को बिहार सरकार सेवा वर्गीकरण नियंत्रण अपील नियमावली 2005 के नियम 14 में अंकित बिहार दंड सेवा से बर्खास्त प्रस्तावित किया गया है तथा उक्त दंड प्रस्ताव पर अनुमोदन प्राप्त होने के उपरांत.
Must be the reason in the appeal.
Yes, Your
For the
Lordship.
principal secretary. Now, Mr. Sanjeev Kumar, there are two things only.
Yes, sir.
There is no allegation of your having procured the appointment.
Yes,
Nothing of that kind.
Oblige, Your Lordship. That is
So
one of
that's one aspect of the matter. But the fact remains that your appointment has been absolutely irregular. So therefore, the justification of holding a departmental inquiry with this kind of charge does not mean anything. But for all practical purposes, even if there is a violation of any one of the rules under PCCA rules of 2005, your appointment on face of it is bad in the eyes of law because the procedure has not been followed. You don't require any law precedent for this. Now, assuming for the time being that we take notice of certain lapses, certain departures in the process, but the end result would be the same because your appointment is against roster clearance. It's against the basic principle of appointment that it should be advertised, post should be done. So therefore, there is a presumption that it is a backdoor appointment. Fortunately for you, there is no accusation against you in the chance that you have contributed to this procurement of job individually without any process. Now, why should this court interfere?
Yes, Lordship. May kindly come to uh, page number uh, page number 98 in Extra 11, Your Lordship.
What is that?
That is this reply I have given to them.
No, that's
No, Your Lordship, the fact of the matter is that, Your Lordship, that my appointment was valid.
Let us
It
see
was
that.
as per the advertisement.
Let us.
आरोप संख्या 1 के संबंध में निवेदन पूर्वक
एक ही आरोप है ना, आरोप संख्या एक क्या कर रहा है?
वही एक नहीं, इसको दो एक और दिया गया है। इसमें रोस्टर आरक्षण उसी को दो ब्रेकअप कर दिया गया। आरोप संख्या 1 के संबंध में निवेदन पूर्वक अंकित करना है कि जिला विद्यालय निरीक्षक दुमका के अधीन राजकीय कन्या मध्य विद्यालय में मैट्रिक प्रशिक्षित वेतनमान की रिक्ति के विरोध नियुक्ति हेतु जिला विद्यालय निरीक्षक दुमका की सूचना पत्र में विज्ञापन प्रकाशित किया गया। सो एडवर्टीजमेंट फॉर देयर योर लॉर्डशिप।
रीड फर्स्ट।
प्रकाशित विज्ञापन के आलोक में मैट्रिक प्रशिक्षित वेतनमान के रिक्त पद पर नियुक्ति हेतु अपेक्षित अर्हता एवं योग्यता रखने का
पहला आंसर तो आपका यहाँ गलत है कि सूचना पत्र पर लिखा हुआ को प्रकाशित नहीं होगा।
नहीं मैम।
लॉर्डशिप दैट टाइम इट वाज
होल्ड ऑन, प्लीज टेक इट।
यस लॉर्डशिप।
प्लीज टेक इट। प्रकाशित जो वर्ड है, you may raise this point, but this is no circulation. Advertisement is for knowledge to the aspirants.
I'll come to that
So
aspect.
therefore read the whole of it and then come.
Yes, lordship. Yes, I am harping on certain things which I
All
consider
right,
that
प्रकाशित विज्ञापन के आलोक में
प्रशिक्षित वेतनमान के रिक्त पद पर नियुक्ति हेतु अपेक्षित अर्हता एवं योग्यता रखने के कारण भागलपुर नियोजनालय में निबंधन संख्या का उल्लेख करते हुए अपना आवेदन जिला विद्यालय निरीक्षक दुमका के कार्यालय को समर्पित किया गया। It means I was registered with the employment exchange.
That's all right. We understand that. You read and then you make comments.
जी, जिला विद्यालय निरीक्षक दुमका विद्यालय उप निरीक्षिका एवं राष्ट्रीय कन्या मध्य विद्यालय गोड्डा की प्रधानाध्यापिका के गठित चयन समिति द्वारा अंतर्वीक्षा में मौखिक प्रश्न पूछे गए, जिसमें दूरस्थ पदस्थापन पे सेवा देने संबंधी में सहमति प्राप्त की गई। प्राप्त सहमति के आधार पर चयनित अभ्यर्थियों के नामों की अनुशंसा हेतु विद्यालय निरीक्षिका बिहार पटना द्वारा जिला विद्यालय निरीक्षक दुमका को प्राधिकृत किया गया और प्रतीत होता है कि संभव उसी प्राधिकार पत्र के आलोक में जिला विद्यालय निरीक्षक दुमका द्वारा अंतर्वीक्षा के आधार पर मेरी नियुक्ति की अनुशंसा बिहार विद्यालय निरीक्षक बिहार पटना, जिन्हें बिहार शिक्षा संहिता की कंडिका 100 में नियुक्ति हेतु सक्षम प्राधिकारी घोषित किया गया था, को प्रेषित किया गया और जिला विद्यालय निरीक्षक दुमका के अनुशंसा के आलोक में विद्यालय निरीक्षक बिहार पटना के ज्ञापन संख्या 183 द्वारा राजकीय मध्य विद्यालय गोड्डा में मैट्रिक प्रशिक्षित वेतनमान के रिक्त पद
आपने अपना जवाब सही दिया है कि ये दायित्व तो अपॉइंटिंग अथॉरिटी का है कि रोस्टर क्लियरेंस करने में।
जी।
The only thing that you can now argue is that I have not obtained the job by any fraudulent means, and when I could see the advertisement, I applied oral interview, and therefore there should not have been a ground. The fact of the matter is that the entire proceeding is vitiated for the reason that the appointing authority should have been proceeded against. Because there appears to be some laches on the part of the appointing authority, but whatever logic you may press, your appointment is not in tune with the procedure established under law. So therefore, dismissal is different thing. Your appointment has to be declared non est per se, because fraud or no fraud, it does not follow the principle. And you are the sole appointee.
No, not the sole. In that school, I was the sole appointee. Yeah.
In that process, you are the sole appointee. So therefore, you could have taken a plea that there has been a cherry picking with respect to teachers. You can't say that because you were the sole appointee. There was no other person in the interview. You should have brought it on record.
I have brought to the document since 2006, Your Lordship.
You should have brought on record that it was not only me who was interviewed pursuant to the advertisement, but there were others also. And this fact has not been correctly stated in the charge. Where is your statement? You have offered no evidence of any kind.
Lordship, Honorable Supreme Court says that is the presenting officer or all inquiry officer, they have to prove the charge, not a delinquent. Number one, Your Lordship. Then again,
I told you in the beginning, you are not at fault. They are not charging you for any fraudulent or corrupt practice. So far you are protected because this will not entail any criminal action against you. But the fact of the matter is that this challenge will not vindicate the appointment because it is beyond rules.
Lordship, it was within the rule, Your Lordship. No.
Oral interview.
No, not Lordship. May kindly
Oral
come to.
Suchna advertisement in Suchna Patrika, and therefore only one person
Lordship,
came.
Lordship, therefore, I impress upon Your Lordship by showing one
We
particular
don't
thing.
see any fault on your part, Mr. Sanjay.
That is not against Your Lordship. That is not against, because it was a prevalent.
We don't find any fault against you personally.
Lordship, may kindly come to page 105, Your Lordship. The type copy.
Where have you argued that pursuant to that advertisement on Suchna Pat, many people came and the process was conducted fairly? Give me one instance and we will interfere because both the authorities, the appellate and the disciplinary authority, have not taken into account. And this is a lopsided proceeding. The inspectors of school should have been proceeded against, which I am going to record now.
Lordship, I have asked for certain documents, Lordship, from them. It's not the case that I have not asked, but they have not given me. It is similar case was taken before.
What document did you demand?
May I kindly come to an extra 2, Your Lordship, page 69, that they have asked you questions in 2006 itself, Your Lordship.
69.
Yes, Your Lordship. In 68, they have asked for certain, they have asked so for notice. Page 68, 2006.
सहायक शिक्षिका के रिक्त पद पर
अनियमित रूप से नियुक्त शिक्षकों का कारण शिक्षा पूछने के संबंध में, तो बिना निषेध से देवर 8 क्वेश्चन।
मेरा नाम नियोजनालय में दर्ज था। रोस्टर क्लियरेंस सर। You are appealing for whom, Mr. Prabhakar Jha?
My lord, I am appealing behalf of the state.
Then one more fact, Your Lordship. Similar question was taken up
We are
before.
waiting for starting another proceeding against your inspectors of school. We are not vindicating his stand, but this is no way to conduct a proceeding.
Certainly.
Lordship, another thing is that a similar question was taken up before Honorable Jharkhand High Court, Your Lordship. Where may I have annexed the order, Your Lordship. May kindly come to reply to the counter affidavit, Your Lordship.
Counter affidavit में क्या लिखा है इन्होंने?
कुछ नहीं, they have written nothing, that it was found satisfactory. Counter affidavit in paragraph 9 they have written.
Just. The facts of the case before Jharkhand High Court was absolutely different.
In Rosary Clearance, they have said that it is a prerogative of the employer.
We are only concerned with this, that there was no advertisement at all.
No, Lordship, even assuming the charge to be true, Your Lordship.
No parallel can be drawn from the facts before the Jharkhand High Court and this court. Unless you have said that this Suchna publication, if you may call it, that attracted students and then something was done. Documents were not.
Lordship,
See, we quite see your point that
I'm
the
just-
CBI inquiry report was not made available to you. Good.
that was taken behind my back, Your Lordship. I was not participated. Nothing was. If opportunity would have been given, or the author of
हम
the
इसे
civil.
set aside भी कर देंगे तो क्या होगा?
Then the author of the charges would come here, Your Lordship. Because may kindly come to page 105, Your Lordship. वहाँ पर हमारा है कि हमारी तदर्थ नियुक्ति होती है और the inspectress of school was fully competent to appoint me. Rule as per the rule provides so.
What is the rule?
Rule says may kindly come to Your Lordship page 105. I'm reading that. श्रीमती नीलिमा कुमारी, the relevant to the last three line. इनकी नियुक्ति पूर्णतः
जो
अस्थायी
किसी सरकारी सेवा में नहीं है को जिला विद्यालय निरीक्षक के अनुशंसा के आधार पर दुमका में मैट्रिक प्रशिक्षित शिक्षिका के रिक्त पद के लिए इतना एवं सरकार द्वारा स्वीकृत अन्य भत्ता पूर्णतः स्थायी रूप से नियुक्त कर योगदान करेंगे।
Now,
Santi Upadhyay, whoever she is, whether she is serving, she is retired, she ought to be in the CBI case, and proceeding should be initiated against her.
now the rule says, Your Lordship, Rule 97 says that the district
Rule
inspector,
97 of what?
Bihar Education Code, Your Lordship. I
Bihar
have
Education.
annexed that page 96.
Yes.
I'm reading at Your Lordship serial number 11 of the said rule, power of the district inspector. To make appointment of class 4 government servants and of teachers in scale of so and so or below the school under her control and to sanction pension to all such cases. Now, Your Lordship, just for a moment of discussion, Your Lordship.
And that's all right, but that is the power of making appointment.
And that was
But what
duly,
is
and
the
that was
procedure
duly,
for making appointment?
and Lordship, therefore what I am impressing upon this honorable court, right from Uma Devi till this date, Your Lordship, the law has remained the same.
Uma Devi doesn't apply
No,
here.
because Lordship was of the opinion that this vitiates because of the backward entry. Now, as per the CBI report, say irregular appointment, not an illegal appointment.
So therefore, no criminal case against you.
Therefore, Your Lordship, if there is a sanction post that is there, if the person is competent to qualify for, I'm qualified to competent to get into the job. The third thing is that if the person is competent to appoint, the person competent has appointed me and has continued for so many periods. So therefore, maximum it can be case of an irregular appointment. Now, Honorable Supreme Court in recent judgment, Bobde Sahab has passed the judgment, Your Lordship, that there
Honorable Justice
I'm
Bobde.
sorry, Your Lordship, I'm so sorry. Honorable Justice Bobde Sahab has passed the order, Your Lordship, when it was held that even in a case of irregular or illegal, now it's not a per se illegal, Your Lordship, maximum it could be, assuming the charge to be true. The charge itself is full of defects, Your Lordship, because in the charge it is mentioned that inka regular appointment hota hai. So therefore, Your Lordship, an opportunity be given and a time may be fixed, Your Lordship, whatsoever. At least the CBI inquiry, had it been done in my presence or I have been called for, I could have afforded this very document I could impress upon them. But nothing was here that the inquiry officer has said, because CBI report आ गया इसलिए ठीक है.
Heard Mr. Sanjeev Kumar, an advocate for the
And there are three judgments of His Lordship wherein I have made a note to Your Lordship where the grounds of challenge I have mentioned. Now this CBI
Just
inquiry.
give me one. We are not on that CBI inquiry, gentlemen. Assuming but not admitting that there would have been any material of a regular appointment for cancelling your appointment, perhaps I would have taken this breach of the process very seriously. That you are not given the copy of the CBI report. We are quite on the same page with you. What is passing on in my mind is that your appointment cannot be made regular because it is sans the rules. That is the whole question.
Lordship,
We are not commenting on you.
Lordship, this can be, in my respectful submission, Your Lordship, this can be this can be examined when the entire document is asked for, Your Lordship, is produced before this honorable court.
Anything that you would have done to...
Your Lordship,
to other-
Lordship, I'm sorry. That
You
this is
could
not
not
my
have-
not my domain to ask
This is
for.
not under your domain, but some
83
information.
selection, Lordship. Till then, I've been continued, promoted, and everything has been done, Your Lordship.
83 you have been selected.
Yes, Your Lordship. The appointment is of 83. Now I'm in the verge of retirement. 15 days after, I'll be retiring, Your Lordship. 33 years I've been working continuously with all
You will
promotions.
be retiring when?
January last 2020.
So with this dismissal, what happens? They will not withdraw salary that you received, your work. So
Nothing.
This
Yes.
litigation ultimately leads you nowhere.
Lordship on the legal aspects, your Lordship, that what I'm submitting or
No,
before
we quite see your point. That you are nobody to explain. They have put you under a charge. They are required to prove it.
that is
There can be no difficulty.
Yes, Your Lordship.
Now you have not been given the charge of the CBI, charge report of the CBI, and therefore you have no occasion to defend yourself. Now, assuming that I take these two grounds very seriously and I set aside the order of the disciplinary authority and the appellate authority, but I'm not going to leave it at that. I would ask for a continuation of inquiry with all the documents to you.
Yes, Your
Now,
Lordship.
would it fetch any benefit to you? That's the question that you
Lordship, at least I won't be prejudiced, Your Lordship, for violation of principle of natural justice.
All right.
A time frame may be given, Your Lordship. 3 months, 4 months. It's not that I'm evading that. It's not that my grounds are not perfect. I'll be showing whatever document they have. A time frame may be fixed, Your Lordship.
What happened in that CBI case?
Kuch nahi, no FIR had been lodged, Your Lordship. This shows that the appeal was taken up, Your Lordship. Thereafter, so many cases were instituted. There have many persons were found irregular. Behind that, the entire proceeding was conducted. All of a sudden, in 2006, they have asked.
That satisfies you. That's all right, but you are not getting any benefit. Just lingering of. Let us see the judgment which you have brought for the consideration.
In one of the judgments, Your Lordship has heard that.
I have heard.
I'm collecting Your Lordship.
I have heard. Did you?
2021 का एक
Citation दिया नहीं आपने?
दे दिया
मेरा जजमेंट क्या है?
एक जो है आपका जिस पे ये है 2019 तक की दिखाइएगा पेज 1120 11 नहीं 2019 का नहीं दिया है अच्छा तो बात नहीं देखिए
2019 का वॉल्यूम 1
अब जो हमारा एक सबमिशन है कि जैसे विजिलेंस केस में एफआईआर को गॉस्पेल ट्रूथ नहीं माना सकता तो उसमें भी सीबीआई को गॉस्पेल ट्रूथ नहीं माना सकता है आई थिंक दैट शुड बी गिवन एन अपॉर्चुनिटी व्हाटएवर आउटकम आई एम रेडी टू फेस दैट इसमें मुझे एक और जजमेंट है शिव दयाल वर्मा का 979 पेज 979 इसी
किस साल का 2019
ठीक है.
हुजूर उसी में 979 देखा जाए पेज 979
किस साल का
सेम उसी में हुजूर 979
2019 का है 2019 वॉल्यूम 3
हाँ 979
वॉल्यूम 3 या वॉल्यूम 1
3 इसमें हुजूर का लास्ट टाइम बहुत maybe the corruption may be there but there has to be the order has to be at least semblance of and Hujur has quoted so many judgments taken into consideration of so many judgments right from the principles brought into practice your lordship.
ये कौन सा जजमेंट है ये कौन सा जजमेंट है
979.
जी
Although I've quoted the principles
Yes, yes.
enunciated in Kranti Associates that it has to be a reasoned order. That's all.
So that is the order is sans reason your lordship both the reason even the inquiry officer has done it perfunctory manner that हो जाता है prove हो गया ये बोल गया there has to be at least your lordship in my humble submission there has to be semblance of at least what the rules provide so whatever the result outcome may be that we are ready to face it your lordship.
When was the proceeding initiated against you?
2006 your lordship the first
And you are the appointee of which year?
83
2006. And you have no idea about the vigilance case, what happened?
नहीं ये CBI case your lordship.
CBI case.
I was appointed on
Can you tell us-
4/8/83.
Now, don't take the plea that since you have not been served with a charge report, therefore you do not know. Since you have been dismissed from service, you will be knowing what happened in the PIL.
PIL में उसमें when the in the contact activity came to we came to know that that when the report was submitted, the PR was it became infectious, Your Lordship. That okay, the purpose has been solved. What I came to know from the
And
contact.
what was the charge sheet and any case proceeded
No,
on the
no,
basis of that charge sheet?
No, nothing.
Do you know this?
Yeah, I'm certain of.
So no proceeding was initiated.
No, nothing. No criminal proceeding. Nothing. No.
Nothing was initiated. Yes, Mr. Prabhakar.
Right.
You rise from the slumber only after 30 years of somebody's doing service.
Right.
And you don't even consider it necessary to give the report. And you don't bring anything on record to say that this advertisement was not an advertisement and only one person was appointed. And if your bona fides are so telling, why have you not prosecuted or why have you not talked about the conduct of the inspectors of school?
Allowed on department.
Let all these things come to the fore and let such appointing authorities be also subjected to proceeding. Give him the copy, give her the copy. Why should you do like this? We are not asking for any reinstatement, not at all.
Certainly.
We'll fix a time. This exercise is an exercise in futility. Nonetheless, he has a ground which we cannot overlook.
My lord, only ground before the dismissal is because of the.
No personal charge.
No,
You have
yes.
not raised any personal charge.
Certainly.
It was very intelligent of you. For the reason that if you had raised anything, conspiracy, Sachi Upadhyaya she would have taken a hit. Okay? But she will not be saved, let me tell you. Has she retired or is she in service?
I don't know, my lord, that she is retired or.
उनकी पेंशन रोकेंगे ये लोग 139 45 भी वो भी नहीं होगा क्योंकि 4 years से ऊपर हो गया होगा. You must inform us. This is bad. These matters should have been brought to the notice of the authorities.
Certainly.
Okay. Heard Mr. Sanjeev Kumar, learned advocate for the petitioner, and Mr. Prabhakar Jha for the state. The petitioner has challenged the order dated 31/8/2020 containing memo number 339, whereby she has been dismissed from service under Rule 14 bracket Roman 11 of Bihar Government Servant CCA Rules 2015, as also against the order passed in appeal upholding the order of dismissal. So the only charge against the petitioner is that her appointment as matric trained teacher in a school way back in the year 1983 was sans the rules, as there was no roster clearance and there was no advertisement for filling up such post. On this solitary charge, the petitioner was put to a departmental proceeding. Be it noted that a CBI inquiry had been held in the matter of illegal appointment of the petitioner pursuant to a PIA petition before this court. The legal counsel for the petitioner has informed this court, and that also without any demur from the counsel for the state, that in the inquiry conducted by the CBI, it was found that the appointment of the petitioner was beyond the rules. The appointing authority, namely the district inspectors of school, may have had the competence to appoint a teacher under the Bihar Education Code, Bihar Education Service Code, but without any advertisement for filling up any vacant post, such appointment could not have been made. Mr. Kumar has further informed this court that except for the filing of such charge report that the appointment of the petitioner was not in accordance with the rules, nothing happened thereafter. Neither the petitioner nor the appointing authority were put to any criminal charge of conspiracy in obtaining an appointment through backdoor. The petitioner continued to remain in service for about 30 years, and during the period that she served as a teacher, she was promoted as well. So the petitioner is shortly to retire, shortly to superannuate. The major ground of challenge of the order of dismissal is that the documents which were demanded by her for an effective representation was not supplied to her. So the only document which perhaps would have helped her frame the answer to the poser, namely the charge report of the CBI, was not made known to her. With about 3 decades having served in the department and having got promotion in the service also, the petitioner was absolutely sanguine that her appointment has been vindicated and as no sequel action was taken after the submission of the charge report. After the submission of the charge report, the learned counsel for the petitioner reiterates that, assuming but not admitting the fact that there was no roster clearance for such appointment to have been made, she could not have been saddled with any responsibility as it is in the domain of the appointing authority. He has further submitted that the appointment was made by a competent person and only after the post was advertised. It appears from the charge memo that the advertisement was not in regular sense, it was not in a regular pattern. The post appears to have been advertised by inscribing it on the blackboard put in front of the office of the district inspectors of school. Mr. Prabhakar Jhan, learned advocate for the state, has submitted that prima facie such advertisement is no advertisement in the eyes of law. An advertisement is meant to disclose information to aspirants in general about the vacancy and the prospective procedure which would be adopted for filling up such vacancy. That the vacancy was advertised only by inscribing it on a blackboard kept in front of the office of the appointing authority is no advertisement in the eyes of law. Apart from this, it has been contended on behalf of the state that no doubt the petitioner has not been charged with any conspiracy for obtaining appointment in an unauthorized manner. But the fact remains that her appointment was not in accordance with the rules and therefore the same cannot be saved by taking resort to the argument that the provisions under the Bihar Civil Service Classification and Control, Bihar Civil Government Servant Classification, Control and Appeal Rules 2005 has not been strictly adhered to in the departmental proceeding. As opposed to the opposite contention on behalf of the state, the counsel for the petitioner has reiterated that in the absence of the report of the CBI having been served upon her, it was not at all open for her. It was not at all convenient for her to answer to the charge that the advertisement and the appointment thereafter was irregular. According to the learned counsel for the petitioner, all that the petitioner can contend is that she was qualified at the time of her appointment to be appointed as matric trained teacher. The appointing authority also had the competence to appoint. The only question therefore remains is that it was not, the appointment process had not been fair, as there had not been any advertisement and there had not been any roster clearance. Assuming but not admitting these two facts to be correct, the charge cannot be saddled on the petitioner in the absence of any conspiracy with the appointing authority. Since there is no charge with respect to such ingredient, which stands further vindicated by the fact that no criminal case was initiated against the petitioner, the petitioner would, according to the argument of the learned counsel, would be justified in raising the plea that even with respect to demonstrating that the appointment was fair and after observance of rules could have been effectively defended if the CBI charge report would have been handed over to her. There is no justification, it has been argued, for not handing over the aforesaid charge report. There is nothing on record also to indicate that the petitioner was the sole person who was interviewed before giving appointment letter to her. No doubt the petitioner did not offer any evidence in support of the contention that her appointment was regular, but the primary job of proving that the appointment of the petitioner was not regular was on the authority concerned. The respondents have not chosen to proceed against the appointing authority, which also is an indicator of malified motives in passing on the buck to the appointee and giving undue protection and patronage to the appointing authority. The last of the arguments urged on behalf of the petitioner is that in view of the violation of Rule 17(3), Roman 2, bracket B of the Bihar CCA Rules 2005, the principle of injuria sine damnum and damnum sine injuria shall apply. Had the petitioner known the contents of the charge report, perhaps her defense would have been different before the disciplinary authority and the appellate authority. A perusal of the disciplinary authority, perusal of the disciplinary as well as the appellate authority reflects that there has been a complete non-application of mind. None of the aforesaid authorities have taken care to find out as to the action taken on the appointing authority when such a singular / solitary appointment was made of the petitioner some 3 decades ago. What was the charge in the CBI investigation is also not known. None of the authorities, therefore, had the curiosity to know about the background of initiation of the departmental proceeding against the petitioner. Merely stating that no evidence has been brought forth on behalf of the petitioner to prove her defense is no application of mind. The authorities have not at all addressed themselves to the issue that the main document which could have been explained, which could have helped the petitioner in explaining away the circumstance appearing against her, was not given to her. There could be no justification in the opinion of this court to avoid giving the charge report of the CBI, which is the basis for initiating the prosecution, which is the basis for initiating the departmental proceeding against the petitioner. No doubt, the tenor of the departmental proceeding is not geared towards saddling the petitioner with any charge of obtaining an appointment by collusive means. But considering the fact that the entire proceeding was initiated on the basis of a CBI inquiry, the report of which has not been provided to the petitioner, the disciplinary inquiry appears to be vitiated and lopsided. The orders passed by the disciplinary authority as also the appellate authority are set aside. While saying so, the court takes note of the क्रांति एसोसिएट्स हमने कहा लिखा है
2019 volume 3 PLR page 979.
While saying so, this court has taken
ऊपर से पढ़ो फिर तो भूल गए Last two lines.
Considering the fact that the entire proceeding was initiated on the basis of a CBI inquiry, the report of which has not been provided to the petitioner appears to be vitiated and lopsided.
Lopsided. Whilst the orders passed by the authorities below, the disciplinary and the appellate authority are set aside. While saying so, the court has taken note of the principles summarized in
Kranti Associates.
Just a minute. In Kranti Associates Private Limited and another versus Masood Ahmed Khan and others, bracket mein likha, reported name 2010, 9 SCC 496. The reason for the paucity of reasons in both the orders impugned, the orders cannot be sustained in the eyes of law. The application is allowed, but with the caveat that the petitioner, but with the caveat that the respondent would provide the charge report of the CBI, provide the inquiry report of the CBI to the petitioner and permit the petitioner to file a response to the aforesaid document, and then the disciplinary authority shall pass a fresh order in accordance with law. To stop, the entire exercise must be completed within a period of 3 months from the date of production of a copy of the order before the concerned authority.
Right.
During this period, the petitioner shall not be reinstated in service, nor would she be afforded any fiscal benefit. The respondent authority shall also consider subjecting the appointing authority to a departmental proceeding as the appointment process was vitiated because of the same not being in consonance with the rules in that regard, equal responsibility would lie on the appointing authority as well.
Obliged.